Everyone has heard of businesses filing for bankruptcy, but what does that mean exactly? Well, it can mean a lot of different things, but first, it depends on what type of legal entity the business is. There are a great many different types of business entities that can be formed in the United States. Sole proprietorships, C corporations, S corporations, LLCs, partnerships, and the list goes on. For purposes of this explanation, I'm talking about businesses that are not a sole proprietorship. So, businesses that are, for the most part, corporations or LLCs. For a corporation or an LLC, most of the time there are really only two different bankruptcy options, Chapter 7 and Chapter 11. A Chapter 7 bankruptcy for a corporation or an LLC is pretty cut and dry. The business files the Chapter 7 case, and the business immediately shuts down and halts operations. It's like a proctor calling time on a test. Everyone puts their materials down and walks away. All of the business assets stay where they are, and no additional work can be performed. As with all types of bankruptcy, immediately upon filing, all collections by all creditors halt. This includes bills, calls, emails, letters, lawsuits, and any other type of collection activity. A trustee is then appointed to first gather up all the assets of the business and then sell those assets. This includes collections of all outstanding receivables. Finally, the trustee will take the money he or she has collected and then distribute those funds to creditors of the business based on a priority system detailed in the bankruptcy laws. This is often a very effective and very orderly way for a failing business to stop the bleeding and wind up its affairs. A Chapter 11 bankruptcy case is a great deal more complicated, but also can save a business from failure. A Chapter 11 is the bankruptcy option for corporations and LLCs that wish to continue operations but can't handle the current debt load that it's carrying. A simple explanation is that the filing of a Chapter 11 immediately halts collections by all of the creditors of the business and allows the business to operate for a time without having to pay those creditors. This can be a period of anywhere from 3 months to 6 months to a year or even longer, depending on the type of Chapter 11 filed and the situation the business is dealing with. Eventually, in a Chapter 11, the business will file a repayment plan that calls for a payment of some or all of the debt, usually over time. How the repayment plan is structured is certainly not a one-size-fits-all type of thing. There is very broad discretion as to how to structure a Chapter 11 reorganization plan. Again, a Chapter 11 can be complicated, but it also can be a lifesaver for both big and small businesses alike. Any type of business bankruptcy case certainly should not be attempted by a non-attorney, and in most cases, not even by an attorney who doesn't regularly practice bankruptcy law. It is a very specialized field and needs a very specialized professional to guide you through it. That being said, this is exactly what I do and have done and have over 20 years of experience doing so. So, if you think that your business needs some help with debt and you need options, call my office. With our experience, why go anywhere else?